Thanks for joining us. This is an NCN News extended interview. We're talking with the Minister of Legal Affairs and Attorney General Anil Nandlall, and we're talking about the representation of the People's Act. It's a hot topic that's been happening in our country. Government just a week ago, through Vice President Dr. Bharat Jagdeo, announced that a slew of laws, an amendment to laws, will be going to the National Assembly before the end of the year. To summarize and to bring us up to speed with those discussions, Attorney General Anil Nandlall.
Thank you very much. I'm fine, thank you, and thank you very much for affording me an opportunity to sit with you to discuss the important issues of the proposed amendments to the Representation of the People's Act.
We said we talk about the Representation of the People's Act. What exactly, for the layman in the street, is the Representation of the People's Act, and why is it so important to have these amendments?
The Representation of the People Act is one of the several pieces of legislation that govern how elections are held in Guyana. Across the Commonwealth, with countries having a similar legal system like ours, elections are statutory. What that means is that the electoral process, step by step, if it begins with the registration of the voter until the declaration of the final results, each step of that entire process is the subject matter of legislation. So you have the Registration Act that deals with registration of persons. Then you have the Representation of People Act that deals with the electoral process beginning from the end of registration to the issuance of the proclamation by the President or the agency authorized to issue the proclamation that declares the date for elections, and then every single process thereafter, which culminates in the declaration of the final results, is the subject of a statute. In Guyana, that important statute is the Representation of the People Act. It is also supplemented by provisions in the Constitution. And over the years, a number of bits and pieces of legislation were passed to supplement and to cover lacunas which would have been identified over the years, or changes made to the law to meet different situations as would have been unfolded since democracy returned to Guyana in 1992. It is that constellation of pieces of legislation that form the basis of Guyana's electoral law. The principal bedrock among those legislation is the ROPA. Why amendments to the ROPA? Perhaps the convenient point to begin is to remind our viewers and our listeners to what ensued after the March 2nd, 2020 elections. That horrendous 5 months period which saw Guyana on trial, democracy on trial, the rule of law on trial, our constitution on trial, and our electoral machinery on trial. For 5 long months, this nation waited with bated breath and in tremendous fear, trepidation, and apprehension in terms of what was going to happen, whether the tyrants would have overcome, whether those who were trying to destroy our country would have been victorious, whether the will of the people would have been trampled upon, whether the Constitution would have been thwarted. All those issues were brought to the fore, and Guyanese and the world witnessed a spectacle never seen since independence in the developing world. And it was democracy on trial, essentially. What we witnessed there was Guyana's electoral foundation, Guyana's electoral edifice, Guyana's electoral machinery as ensconced and entrenched in the various statutory provisions and the Constitution, but in the main in the Representation of the People Act and the National Registration Act being shaken, being attacked to its very core. And it took the fight of the people, the fight of the international community, the stamina of leaders in this country, and the credibility of certain components of our judicial structure to defeat the attempts to steal democracy and to fight off tyranny, which were threatening to take over our government and our country. Whatever weaknesses were in the law, they were exploited to their hilt. Wherever there was discretion, it was abused. Wherever there was latitude, interpretive latitude, it was vulgarized. Wherever there was an opportunity to bend the law to the repulsive end, it was exploited. These amendments, in the main, are intended to address those exploitations, absurdities, and vulgarities which were revealed during that 5 months period. It is recognized that no matter what law you put out there, if you have perverted minds, if you have tyrants, if you have authoritarians in charge of the system, they will pervert the best law and they will misinterpret deliberately the clearest of language in pursuit of their morbid end. So legislation alone and change in the legislation alone may not be enough to fend off the type of attack which Guyana was under during that 5 months period. But as far as possible, we made a commitment during that period to the people of our country, we made a commitment to the international community, and we are duty bound to ensure that whatever weaknesses we can identify and whatever weaknesses we saw being exploited during that period, to take the necessary steps to rectify and remedy those deficiencies. And these amendments are largely designed to achieve that purpose.
To achieve that, you mentioned a few things in explaining where the country came from to where we are now, which is the amendments to the ROPA. And you said exploitation of weaknesses. A few questions come up. In the discussion, in the amendments proposed, stakeholders were involved in looking at this. That process took roughly about a year and change, and this is, government was sworn in on August 2nd. We're into 2021 now, so just about a year and 3 months over, if my math is correct. How was that process? How much fleshing out and amendments and changes were made to the act?
All right, so if you were following the litigation which preceded the elections and then succeeded the elections, you may have recalled the Chief Justice, the Honorable Roxanne George, on more than one occasion lamenting on the state of disarray that our laws are in relation to the elections and the electoral process. So the first task was to accumulate the laws and try to put them in chronology. That is not an easy task. Unfortunately in Guyana, because of our peculiar political circumstances, at every elections since 1992, we have had peculiar problems as we approach elections. You have a PNC that is always finding ways and means, or trying to find ways and means, of thwarting or polluting the democratic processes. The record is there for anyone to examine. So at every elections, we have had this challenge of trying to accommodate, trying to facilitate sometimes unreasonable requests coming from that opposition party. Most of the years they have been in opposition. 1992 itself was the beginning of that process, where we had massive revolutionary changes, beginning with the way that votes were counted, the reform and reconstituted elections commission, the way the chairman was elected, and we know all that history. Every election after that, we have had changes as a result of these demands being made by the PNC. And someday one must sit down to examine why they are making these demands. And let me tell you what my views are. Peripherally, they can't win an election by popular ballots. They can't. They were able to win in 2015 because of a coalition. And they can't win again because that coalition is destroyed, and they destroyed it, but that's a different debate. So, because they can't win by popular ballot, they have been titillating, interfering, and trying to adjust the electoral system, the laws, the constitution, the electoral machinery, all in an effort to win. And that is what has inspired marches and unrest preceding many elections in this country and succeeding elections. So 1997, they had massive unrest on the streets. They wanted the use of an ID card. They went to the parliament and they agreed that an ID card should be used as a method of identification purposes for the voting. After the elections, and a law was passed to that effect. After the elections, when they lost, they attempted to burn down the whole of Georgetown. They beat, they marched, they robbed, and then they went to the court to challenge that very law that they unanimously passed in the parliament upon their own behest for use of an ID card. I give you that as a graphic and vivid example of the type of challenges that the PUP government has had to undergo over the years. And the law has been made the victim. So they changed the law. And we all change the law. We contribute because you buckle under pressure. You want peace. When you don't accede to these requests and agreements are not arrived at and political consensus are not met, where you have violence in the streets, mayhem, disorder. A country can't continue like that. So you meet and you make compromises in the interest of peace and good governance. But sometimes the compromises are not in the best interest of the law. So the law keeps changing and changing to meet every elections. Now, when those elections are passed and they are concluded, there has not been, unfortunately, an effort now to repeal those laws which may have been peculiar to that elections. So these laws may have been passed because of a particular exigency at the time. and the political parties, for expediency, adjusted the law to meet that eventuality and that exigency. When that election is concluded, that law is left there. Fortunately, in relation to the ID law, the court had declared the law unlawful. So that by itself could not have been used, or else that would have been left there too. And some future elections, we would be wrangling over whether that law is applicable. It happens right now, where you're hearing a call for house-to-house registration, when that is impossible in the face of a statutory process that mandates cyclical continuous registration. Both can't exist. They are mutually exclusive processes. It's either you go to a one-off registration when elections approach, which was the system that we had prior to 2001 or thereabouts, or you go to house-to-house registration, or you go to continuous cyclical registration, which is the system that we imposed and which is now in force. But because we never, I believe, clarified the law, you can find a lawyer disingenuously holding up provisions of an amended act that really speaks about a house or the semblance of a house-to-house process, though we have continuous cyclical registration, which contradicts. These contradictions are still in the law. We have to weed them out. I say all of that to you to get back to your question. I mean, it has been a long-winded effort to answer you. The exercise has been an elaborate one. It's a complex one. And this is only the first installment. And I walked with the volume so that the populace can see. This is the amendments along with the act, along with proposed regulations, right? So I saw Stabrook News editorial today criticizing the government for, I gather, the delay in the completion of this exercise. But the author of that editorial, I am sure, did not look at this document. I don't doubt whether they would have read this document. So they have no appreciation of the magnitude of the workload as well as its technical nature. Now, this is only ROPA. We have to deal with the registration component of the exercise, and that is going to be released shortly as well. So it is a comprehensive undertaking as well as a technical undertaking, but it's an undertaking of fundamental importance which we are committed to, and which, as a matter of fundamental democratic our fundamental democratic architecture, we have to implement.
Two questions come to mind. One, with these amendments coming up, how many amendments are we talking about in one? And two, when you actually get to the Parliament to have this discussion, the National Assembly, are you expecting the support of the opposition in this debate?
In terms of numbers, it would be not impossible, but difficult for me to identify the numbers, because one amendment can have 15 parts, subsections. So what are you considering an amendment? It may be an amendment to one section of the law, but it carries 15 or 10 subsections. So I can't answer that question. But there are many, or manifold if you wish. They are all intended to strengthen the democratic process. They are all intended to make the process transparent. They are all intended to make the machinery accountable. So discretion, as I said, is being eliminated and or reduced. Things that are blurred or ambiguous are clarified. Let me give you a couple of examples. So I say that also to make this fundamental point, and I want to pause here to make this point. These amendments are not intended, and great care and circumspection were employed to ensure that that is clear. They are not intended, they are not designed to give any political party an electoral advantage. I want to make that abundantly clear. They are all designed to strengthen, make more accountable, make more transparent, make more democratic our electoral machinery, to make it stronger, to make it more durable, and to make it familiar and clearer to the ordinary man. So some of the issues, let me deal with some of the issues that we have frontally addressed. First of all, let me say that our electoral laws is about 100 years old. And in any event, whether you had Lowenfield or Mingu or not, they are due for review. That's the first thing. No law that is 100 years old can really continue in the same place and same way. So that's the first thing. But there are areas that we have clarified. For example, manuals, just a simple thing as manuals. What have been happening at GCOM is that the Chief Elections Officer decides to supplement the law by the issuance of manuals authored by him. These manuals sometimes collide with the law. But most importantly, they are ad hoc instruments that they are, I don't want to say concocted, but they are created by the CEO, the Chief Elections Officer, and kept internally. Sometimes the Commission doesn't know about these manuals. Commissioners do not know about them. They are sprung upon parties very close to election time. And these are the manuals, for example, that you are told that the presiding officers must use, that the polling agents must be guided by, that the returning officer must be guided by, that employment practices are governed by. Now, most of these things, as I said, in an electoral process, are the subject of express statutory provisions. You can't have a manual that is now going to supersede the law that may be inconsistent with the law or that was made without comparison with the law. That is a common thing at the GCOM. And that simple thing causes a considerable amount of confusion and controversy elections after elections. That has been clarified. The manuals must be consistent with the law. They must be published on websites. They must be made available to all the political parties, and they must not be promulgated within a certain time before the date of the elections. So parties have enough time to acquaint themselves with the manuals. Polling stations. We have had the situation where the CEO determines by himself almost where polling stations are going to be located. And there are no clear criteria that guide the exercise of that discretion of the number of polling stations in one locality or electoral division, nor is there the criteria of how many people are likely to vote there. Those issues have been clarified. We know where we know what are the criteria that will be used to establish a polling station within a division. What factors you must take into account. You got to look at the number of voters likely to vote there. And we have a number that we stipulate. You can't have more than X number voting. You have to look at the distance that the voter has to travel to arrive at that polling station. You have to look at the natural environment of the polling station. We try to keep persons within their particular locality. So the people of one village must not have to go to another village to vote. Guyana has peculiar physical and political considerations that are reflected in the villages. You want to minimize those areas that can erupt controversies at elections time. And then there are some fundamental changes that directly address tabulation of results. That is, to avoid the disaster which we witnessed taking place at Ashmin's building first, and later at Kingston GCOM headquarters, perpetrated by the returning officer of District Number 4. That is an issue that was addressed frontally. District Number 4 is a special district in the electoral equation of our country. It is the most populated district. It always has the greatest number of controversy. So what we are proposing in these amendments, we are subdividing it into 4 units. So you have the East Bank, you have the East Coast, you have North Georgetown, you have South Georgetown. Each one is compartmentalized in terms of staff, in terms of infrastructure, in terms of regulation and rules and system and procedure, as if it is an electoral district by itself, self-contained. So instead of 1 Mingo, you will have 4 Mingos. When I say Mingo, I mean the good one. You will have 4 persons tabulating.
4 persons tabulating instead of 1.
So the East Coast results will be tabulated at differently and at a separate location. East Bank separately, South Georgetown separately, North Georgetown separately. So that when you have them together, we saw firsthand what the possibilities are for wickedness. We have also clarified how the tabulation is to be done and who are to be present and what role they must play and when the tabulation must begin. All these things you had ambivalence about. They are now clarified.
Gray areas
right?
Now being clarified.
So the statement of poll, whether it's projected electronically or whether it is utilized in a different way, is the basis for the tabulation of the results. Nothing else. So the era of the spreadsheet and the bedsheet has come to an end. Statements of poll. And also you have the statements of poll upon receipt of the statements of poll by the CEO, and it must now go to the chairman of the Elections Commission. The statements of poll as they are coming in. And once they are in, they must be posted by law. They must be posted on a website, GCOM website, where the whole world will see. So when we are tabulating, and you see, and there is nothing unique about that. And that is the whole intention of nailing it, for example, on a building. Now, 100 years ago when the law was drafted, we didn't have internet. So nailing that statement of poll on a conspicuous part of the building that was used as a polling station was the publication of that result. So when the returning officer was tabulating that result, it was already known by the public. All we are doing now is to get that done, but using the technological advances and apparatus that are available. So no one can say that we are introducing any new element into it. The idea behind the law was to make the results public as quickly as possible. Then the only way to do it was to nail it on that building. Now we have the magnificence of a technology called internet, and we are going to use that. So that is how, and then I can go on. These amendments are so important that I want to take this opportunity to invite every single citizen to take a copy, get a copy. They're clearly written, they are nicely formatted, the amendments are there and they are attached, the law is attached, so you can read the amendments and the law at the same time in one consolidated document. It's available on our websites, and it's available, it has been physically distributed to a number of organizations. Every civic and civil society organization should get a copy of this. Every newspaper should get a copy of this. Every journalist should get a copy of this, and this should be a national discourse. This is not a political issue. This is an issue of national importance and of societal importance. This issue has demonstrated by itself that it can make or break Guyana. And I would presume that every citizen would want to have a say in their future. This constitutes part of their future.
How does every citizen have a say in this document?
Well, Minister Teixeira will unfold a program how the consultations are going to go. Right now, I believe persons can submit their recommendations and their advice or their adjustments and amendments to the various websites, and there are ways by which you can do that. But I will leave it up to that minister to speak on how that exercise will take place. Another important component that was addressed, which came to the fore during the last elections, was of course how you total the results. In my view, the law was very clear. But you had a chief elections officer that simply decided to act with perversity. So, however we could have made it clearer, it has been made clearer. When the tabulated forms are transmitted from the respective returning officers to the CEO, that tabulated form or those tabulated forms is the only basis for him to come to a computation, to use in the computation of his results. And that becomes the national results, the final results, which he is to put in that report and give to the commission. So what is intended, the golden thread that runs through, is that the ballot is protected at every step of the way. And the ballot, or collectively the ballots, at the end is counted, and that forms the basis for the final declaration of the results. And that is what an electoral system is intended to achieve ultimately, if it is to reflect the will of the people. Because that ballot reflects the will of the people, and that is the singular and most fundamental purpose of an electoral cycle or process.
A lot of discussion surrounded a lot of things that happened. Most of that, and one of that was chief of there, was what the coalition was saying, with a lot of persons from out of the jurisdiction voting, and of course one of the big ones that came up, dead people voting. And the amendments that come with that, how is that going to be addressed going forward? And then it comes back, I guess, to
you
the registration.
can't address dead people voting because dead people cannot vote. I can't craft a law or preside over the drafting of a law that says that dead people cannot vote. I mean, what, are we a laughing stock? So you have to decipher nonsense from sense and discard nonsense in the nonsensical basket. I can't draft a law that says ghosts cannot vote, because really, physically, they can't vote. So you have to be wary of that type of political rhetoric and just toss them aside. Our Constitution is very clear, and it has been pronounced upon by our court finally and decisively, that the qualifications to vote are as follows. 1, you must be 18 years and over. 2, you must be registered to vote. 3, you must be a citizen of Guyana. Once you satisfy those 3 requirements, you are entitled to vote as a matter of constitutional right. There is nothing I can put in any law, or anyone can put in any law, to detract or derogate from these 3 requirements. In fact, that is what in 1997 there was an attempt to do by the use of the voter's ID card, adding a 4th element as a qualifier to vote, which was possession of an ID card. And that is why the court said that is wrong, because the Constitution is the supreme law, and the Constitution prescribes 3 ingredients only. So, whether the people live in America, they live in England, they live in Australia, or they live in Timbuktu, once they are Guyanese, they are 18 years of age and over, and they are registered to vote, they are entitled as a matter of constitutional right to vote. And that must be understood. If you want to change the Constitution, well, that's a different thing. These amendments are not intended to affect or alter the Constitution. We said in our public commitment that we will propose amendments that we can pass using our majority in the Parliament. We will not endeavor to undertake an exercise that we have no control over when it reaches the Parliament. To change that issue in the Constitution requires a 2/3 majority. We don't have that. So we are not directing our efforts in that area. There's a constitutional reform process which will begin in due course. That is the process that we may wish to use to target constitutional changes. That's a different exercise, qualitatively different from what we are engaged in now. These are statutory reforms. So we can't, the law is very clear constitutionally as to who can and who cannot vote in Guyana.
AG, in our last 5 minutes as we talk about this, we talked about some of the major amendments coming. We've talked about how one can have his or her input as a citizen or as a group or as an organization. When realistically are we looking at taking this to the Parliament for discussion?
Well, we would like to take this at the earliest possible opportunity. The problem is that while we want to take it early to Parliament, we also want to have the widest possible consultation on it. We want the widest possible engagement at the level of the political parties as well as at the level of civil society. So those are the competing interests. I'm hoping that we will get response quickly. I see there's an organization called Article 13 that is issuing statements and so on. This is the work that they should be doing and sending recommendations. And the civil society organizations, and there are certain grouping of people who feel that whoever is in government, they should criticize them, whether rightfully or wrongfully. Somehow criticism of a government gives them some independence of mind. I get that feeling in certain segments of the society. Maybe it's a sophisticated thing. An uneducated person like me can't appreciate the sophistication and the intelligentsia involved. But I know that there is that caliber and grouping of persons out there. I invite them. Here is an opportunity to be critical of the government and criticize constructively, however, the proposals that we are making. And let us see whether you can put forward something better. Our government is committed. As I said, the purpose of this is to strengthen the exercise, the machinery, to make our democratic process more durable, make our democratic machinery more impenetrable, to make it modern, to make it responsive and responsible, to make officers who are employed in the process accountable, to put to make their actions transparent. Those are the ideals that inspire these amendments. Any contribution from any quarter that advances those ideals, we will welcome them. We will welcome them. We don't pretend to have a monopoly of knowledge. We don't pretend to be the repository of what is good for the electoral process, but we have put forward what we consider to be our best efforts. It's a national process. It's not our process. It's a national process. This is for the national good. This is for the benefit of every single Guyanese. This is to enhance and augment our democratic credentials. Nobody can suffer any loss or any negative issue as a result of this. None. This only good can come out of this process. There is a second set of amendments that will bear the same mold and will enjoy the same attributes, and that is those dealing with registration of electors, where we will clarify the registration system. We will try to get a system in place that will remove dead people effectively from the list, so that the issue of zombie voters will not arise with the frequency that it is arising. We will also ensure that there is clarity when it comes to registration and the system that will be used for the registration process. Can you just stop the system, throw away the database, and start all over again? That seemed to be the view of one set of people. My view is the system does not permit that. That you have a database and you have to build on it and you have to cleanse it at periodic intervals. And the law exists for that to be done, but if we need to enhance it, if we need to clarify it, if we need to augment it, then that will come out in the recommendations that we will put forward in relation to registration.
AG, Minister of Legal Affairs, Anil Nandlall, thanks very much for explaining to us. We've come to the end of this discussion talking about the Representation of the People's Act, and of course we're hoping to see this in the Parliament very soon. And you can you will of course have your opportunity, whether as an individual or as a group, as an organization, to make your contributions to that. I am Leron Bramwell. Thanks very much for joining us for this NCN extended piece. Have a good one. Be safe.